Good afternoon, everyone. My name's Sandra Grossman, and I'm an attorney at the law firm of Grossman, Young, and Hammond in Bethesda, Maryland. For the past 15 years, I've focused my work on the practice of U.S. immigration and international law, and my firm covers deportation and asylum cases, family and employment-based immigration, as well as international human rights claims. I was asked by the American Society for International Law to moderate a panel on the U.S. immigration system and laws, as well as recent executive actions in light of international law and norms. These topics are certainly timely. The U.S. immigration system is the topic of much debate and consternation for people on both sides of the U.S. ideological spectrum. The Trump administration has made the issue of immigration reform a centerpiece of its reelection strategy. This, despite recent polling, which shows that most Americans continue to be in favor of immigrants and immigration. In any case, whether you're Republican, Democrat, or independent, most people are keenly aware that our immigration system is broken on many levels and desperately in need of repair. In this panel, we will focus particular attention on the immigration law positions and policies that have been most at issue during this election year. Our esteemed panelists, both of whom have worked in the U.S. Senate on the issue of immigration reform, one for the Republican Party and the other for the Democrats, are now in private practice and will represent the views of their respective parties. Neither panelist here purports to represent the views of the Trump administration, though each will analyze the administration's policies in light of their party's political perspective. The goal is to gain an understanding of each party's views and identify what we can expect in terms of immigration policy under a Biden administration or under a continuing Trump administration. So I'm going to briefly introduce the speakers. First, we have Enrique Gonzalez, who is the managing partner of Fragament's Florida office. In 2013, Enrique served as special counsel on immigration to U.S. Senator Marco Rubio, where he was the senator's principal advisor on the Border Security, Economic Opportunity, and Immigration Modernization Act that was approved by the Senate in June of 2013. Enrique will be representing the Republican perspective. Leon Fresco, the other panelist, is representing the Democratic voice here, and he is a partner in Holland & Knight's Washington, D.C. office. Leon was the primary drafter of the comprehensive immigration reform bill that Enrique also worked on, so they go way back. And at that time, he was principal advisor to Senator Chuck Schumer on all aspects of immigration law and policy. Leon was also previously the Deputy Assistant Attorney General for the Office of Immigration Litigation at the U.S. Department of Justice Civil Division. Now, both Leon and Enrique provide global immigration representation to businesses and individuals. So we've got 4 main topics that we're going to be covering today. The first one concerns asylum and refugee law and policy. So I'm going to ask a series of 3 different questions and then give each of you time to answer. So first, the first question on this topic concerns asylum seekers. So since January 2019, over 60,000 asylum seekers from Central America, Cuba, Venezuela, and Brazil have been returned to Mexico under what are called the Migrant Protection Protocols. The current administration has implemented a slew of programs, which are basically meant to, some people would say, deter individuals from being able to seek asylum through policies like the Asylum Cooperative Agreements, which return prospective asylum seekers to El Salvador, Honduras, and Guatemala. They've implemented border closures, especially during the pandemic, metering, which is limiting the number of people allowed to cross into each border city, and fast-track deportation programs. The courts, for the most part, have fallen in line with these programs. For example, the U.S. Court of Appeals for the D.C. Circuit upheld the administration's expansion of expedited removal recently, and the U.S. Supreme Court also recently held that federal law limits habeas review obtainable by a non-citizen who's detained for expedited removal. So again, Combined, some would say that these policies form an ever-present and increasing barrier to due process protections for migrants. So we're going to address the international law implications in a follow-up question, but first let's deal with the legality of these provisions or measures under national law. Leon, the first question's for you. Assuming that Biden is elected, there's likely going to be a continuing crisis on the southern border and in the northern triangle countries. How do you think the Biden administration would handle this crisis? And do you think they will keep, modify, or remove the measures put in place by the Trump administration?
I think this is a challenging question because there's two dimensions to it. Number one, there's a pre-COVID and there's a post-COVID, or during COVID and after COVID scenario. And I think if the Biden administration is elected and gets into office, the COVID situation on the ground may not necessarily be that much different in January than it would have been right now. And so some of the Title 42 protections that are being put in place in terms of turning people back, I think will probably be kept for some time, because you have a very difficult scenario of trade-offs here, where you have to decide, do you want to keep people in a CBP facility for some period of time where the COVID spread could be worse? Do you want to let people in without that time period in the CBP facility, which we've never done? We've never bypassed the CBP facility part of the intake process. Or do you want to turn people back? And so now the question is, how long can you keep turning people back without them coming back over and over again? But that's sort of the first process of it. Then, in a world where COVID is back under control, I can see these parts of these things being decreased on an incremental basis. So, for instance, the aspect where asylum is banned for people who don't use the ports of entry, or where asylum is banned for people who don't go through a third country first and ask for asylum. Those bans, I can see those being lifted, and then seeing on an incremental process, okay, how many more people are coming across the border at a given time? But the migrant protection protocols, I would see as the last thing to be eliminated. It might be eliminated, but it won't be eliminated at the same time, because what I think will happen is first of all, that was being considered during the Obama administration as one of the potential options. It was just never put into place. And so the question is there a way to operate that migrant protection protocol that actually would work in terms of respecting due process? Could you pay for lawyers? Could you get people, access to counsel? Can you get people the resources they need to actually make those cases? And if you could, I think that would be a very interesting conversation with the advocacy community about what's preferable in a world where there's that, or there's detention, which no one likes in the advocacy community, or detention and very brief detention and release, which is the sort of problem where if you do too much of that, you create the surges that any administration doesn't want to see on the border. And so what I'm saying is I think that's going to be a very incremental turn down. It won't just be a sudden switch that's turned off and we return back to 2015. I don't see that happening.
Mm-hmm. Just a quick follow-up question on that, Leon. What about sort of the legality of some of these measures? Like, for example, there's well-established case law under asylum law that individuals who express a fear of return have a right to a credible fear interview that they can apply anywhere, even if they don't show up at a lawful port of entry.
Yes.
There's also case law about that basically that would talk about not having to be sent back to a country where reasonably they might face other basically injuries, or it would be unreasonable for them to go back to a third country. Do you think the Biden administration is looking into sort of the legality of some of these?
Well, sure. I don't think that the administration will take the position, and I think they will strongly advocate for the position that the asylum statute as read, as written, says that you can apply for asylum anywhere in the United States. I mean, that's what I read when you look at that statute. The plain text of it seems pretty obvious to me that the only place to apply for asylum isn't at the port of entry. The question is, I think it becomes a matter of, yes, they'll take that interpretation. Where will they take that interpretation in? Will they take it as a settlement to one of the lawsuits that exists right now that's challenging that issue? And if they take it as a settlement, then that's potentially something that could operate much like the Flores settlement agreement operates today, where it's actually quite hard then to undo it. And so you start to see that rights are created by, in concrete by some of these court settlements. Or will they just take it by simply unwinding the 212F proclamations that the Trump administration made, which is how they put these things into play. They just said, we're not going to accept asylum from people who don't apply in a third country, or from people who don't appear at a port of entry.
Okay.
And so, sorry for that length of time.
No, that's fine. And we'll get to those proclamations in a subsequent question. Enrique, can you respond to some of the comments that Leon has made here? And in particular, I'm interested in understanding if you believe, from the point of view of the Trump administration, if the administration's policies are legally justified, and if so, why, under US law?
So let's start off with the first concept, the legality of these actions under current law. And I think if we look at Section 235 of the Immigration and Nationality Act, which is where the Trump administration rests a lot of its decision-making authority to take these actions, in particular, for example, the MPP program, that it is something that is provided for and it is permitted. But I also would say that the Trump administration doesn't necessarily hold itself or is beholden to those particular sections of law. In the understanding and the concept, and when we get to the issue of international law and the Convention of 1951 and the Protocol of 1967, which we'll talk about a little later, is that we don't have to adhere to these ad infinitum, that there is a time for a change, and that time for a change has come now. And a lot of that is predicated on the basis that there is substantial abuse of the asylum system and asylum program in the United States, that the United States has been extremely generous and people are taking advantage of this. When you look at, for example, from the Northern Triangle, Honduras, Guatemala, and El Salvador, that 90% of the applications for asylum at the end of the day are determined not to be credible, whether it be in a interview at a facility in Mexico, or whether it be through a finding by an immigration court judge in the United States. And so that is what the major problem is that we have here, is that the system is broken. The system needs to be fixed. And we find that there's sufficient authority under 235 of the Immigration and Nationality Act, as well as 212F of the Immigration and Nationality Act, for the president and the administration to take the actions that they're taking. Now, the actions that the US has taken are also not actions that are unique to the United States. We have seen these actions taken by other governments around the world. Particularly, Australia has done this with the boat people in Southeast Asia. We've also seen this. Greece has had to deal with the same exact situation, as they are on the front line for Europe. And so what it really does is it opens up a new conversation that has to be had on an international level about the responsibility of those other countries through which these people are transiting, number one, the responsibility and the ultimate responsibility of why does the United States needs to carry the burden. We understand that the United States has always been the beacon of light and hope for thousands, if not millions of people. But at the same time is fraud has overtaken this program. I'm not saying that every claim for asylum is a fraudulent claim or that there's abuse there, but there's a significant portion of those applications which are. And so that the Trump administration has taken the steps that it has to in order to weed out that fraud. And so that we can get to those cases which are legitimate and give those individuals the opportunity. You need to start presenting a disincentive to individuals to abuse the system. If you can enter the United States, be released on bond or without need for bond, and sit in the United States for 4 or 5 years before you actually have a meaningful hearing in immigration court, That is what is lending to the additional abuse and fraud. People know, oh, I have no other immigration alternative. I'm coming to the United States, and I know how I'm going to stay, and I know how I'm going to get a work authorization, which will allow me to start working. We then have to deal with the equities later on.
So, Enrique, let me ask you, because some people would respond to the issue of fraud and the credibility issue that you bring up, saying that, it's very difficult to win an asylum case. You have to show that you fear persecution on account of a protected ground, race, nationality, religion, membership in a particular social group, political opinion. Ideally, you want to be able to show, well, there's high evidentiary burdens, but with these protocols that have been in place, people really don't have the ability to hire a lawyer to gather evidence. I mean, they're being put in sort of tent cities and borders with the metering. Only a few are allowed in. There's certainly no access to counsel. And these are people that have, very limited amount of resources, if any resources at all. So is it really, when you put people that are in that situation in front of a judge to prove credibility in an asylum case, and you're taking away those due process protections, isn't it kind of sort of too easy to say, well, they're deemed not credible, but isn't it also because they're missing these due process protections that they would otherwise have?
Well, the question is, you have to draw a balance at the end of the day. And you have to balance the security needs of our country versus the ability to extend further or grow out further the due process needs of the individual who's seeking asylum. Definitely agree, and we'll talk about this a little later when we get to the issue of the protocol and the Convention for Refugee Status. But at the end of the day, there have to be limits. If not, it will only continue to engender the abuse of the system and the fraud. And so I understand and I respect that there are individuals and it is extremely difficult. There are also psychological, psychiatric conditions that may impact whether an individual can actually make that case for themselves while they're living through the shock of the situation. We respect and I understand that. But it becomes a question of trying to balance it out. These individuals, in many cases, are coming from Honduras, Guatemala, and El Salvador, and they're making it to Mexico. Mexico bears part of the responsibility here as well. So individuals who are crossing through third countries, why should an individual, I'll give you an example, which is a very outrageous example, but nonetheless an example, is an individual who lives in Venezuela, for example, who has a Spanish passport, who can enter the United States without the need for an actual visa because under the EFTA program they're allowed in. They transit through Spain, sit in Spain, enter the United States because there are no direct flights from Venezuela into the United States. So they have to transit through a third country. They have passports of other countries. They get to the United States. And this is, by the way, a frequent example. They get to the United States, they file for their asylum, but they also simultaneously renounce their Spanish nationality. Well, are they claiming asylum from Spain or are they claiming asylum from Venezuela? Now, this is a unique example that we've seen here in South Florida, occasions where this has occurred, where individuals, because they want to be in the United States, they had the opportunity to firmly resettle in the third country, which was a safe country, a safe destination such as Spain. And so this is just one example of the type of fraud or abuse. I wouldn't call that necessarily fraud, but I do call it abuse of the system. And it gets into the hundreds, if not thousands of cases. And what it does is it puts the individuals with bona fide claims for asylum in a difficult predicament because the volume has become so large that we have to stop it. We have to create a disincentive. And that's what the whole MPP program is about, is creating a disincentive. And we also need to recognize that a lot of individuals who are coming to the United States through asylum, and again, I don't want to discredit or say that there aren't bona fide claims to asylum. There are multiple bona fide claims of asylum out there. They exist. They're legitimate. The question really becomes for us as a government is to try to weed out those claims which are fraudulent or which are abusive because a cartel has somehow begun to abuse the system in order to be able to get people into the United States for whatever motive they are doing. And it's not necessarily or always limited to drug trafficking. Maybe human trafficking that we're talking about. Because the cartel is collecting at the other end from the family as they traffic the individual to the United States. They charge a premium so that the individual gets to stay, and that's why they file the false asylum claim. And again, there are multiple examples. There are anecdotal examples. I do not have statistical information. I don't rely on statistical information too much because as W.C. Fields, if anyone even remembers who W.C. Fields is at this point in our lives, used to say there are three types of lies, and they are statistics, statistics, and statistics. But at the end of the day, it's a matter of creating a culture that people understand that when you come to the United States, you're going to have to do it the right way. You're going to have to obey the law. And the respect for the law is one of the things that we're trying to engender with this type of system. Again, there are good apples in that barrel who will suffer because of the bad apples, but that we have to balance out which one is more important, stopping the abuse and the fraud so that we can take care of those individuals' legitimate claims, or just letting everyone in and just being a free-for-all party as it has been in the past.
Okay, thank you, Enrique. Leon, unless you have a quick response
I
to that.
just, for 30 seconds, I would just
Yeah.
say one quick point that might be helpful to the viewers is, to the extent that these claims are recognized as particular social group claims, the ones that are made by Central Americans, which is based on whatever the Attorney General basically, how they want to define those claims, that will dictate how frivolous or non-frivolous they are. And so that becomes a very important variable when you move forward in the Trump administration or the Biden administration, is the two types of claims you saw, which are gang-based claims and domestic violence-based claims, are right at that sort of gray area of a particular social group that is a very hard area to kind of grasp around. And so the Trump administration has tried to say, no, that's not that can almost never form a particular social group. And the Obama administration had tried to give some more wiggle room there. And I think that will sometimes dictate how frivolous or not frivolous these cases are.
Okay, thank you, Leon. So I'd like to get to the second question, which has to do with international law. So here, critics of the Trump administration policy argue that the administration is in violation of not only US law, but also international law, and specifically the 1967 protocol relating to the status of refugees, to which the United States is a party. The protocol establishes that the US may not return asylum seekers to face threat to their lives or freedom without, one, affording them an opportunity to apply for asylum or for protection against the threat of torture, and two, conducting a full and fair examination of their claims. In summary, the protocol establishes that even in times of emergency, governments remain obliged to protect refugees from return to a threat of persecution. Leon, can you address how a prospective Biden administration might address these international law norms in a way that would differ from the Trump administration? And what do you think are the US's obligations under international law?
Well, I think this is a tricky question because, and I'll start with the actual legal question, because I think that the Refugee Convention ties in pretty much, in my view, and I'm not speaking for anybody else, with withholding of removal. I think withholding of removal is what's required under the Refugee Convention, which is that you don't remove somebody to a place where they are likely to face persecution, or withholding of removal under the Convention Against Torture, where they're likely to face torture. Asylum is sort of an extra bonus that you add, from the context of who is entitled to get this right to have a green card one day and then a path to citizenship. And there, the refugee conventions don't mandate that you have to give asylum on a basis where if you do this, and this, you have to get asylum. There's much more wiggle room that countries have with regard to what they are able to do with refugees. And so the question is, well, what did the U.S. Congress do when it was implementing these 1967 agreements? Because that, in the end, is what's enforceable in court, is what the U.S. Congress did to implement these agreements. And my argument would be that the one thing that I think for sure the Biden administration will walk back is the concept that there are any kind of barriers to getting asylum. All of the barriers that were created in the Trump administration, the legal barriers, the barriers in terms of if you do this, you can't get asylum, I think all of those barriers will be walked back. Now, how will they be walked back in terms of what the mechanism will be by which you apply for asylum? This is going to be another question. This is why I'm saying I don't know exactly the phased implementation of how this will work with COVID and with MPP. But if someone is going to go through an adjudicative proceeding, whether they are in Mexico or whether they're on the border or wherever they're going to be, I can say this part with pretty much universal certainty, that the political pressure from the folks who are friendly, and it's even inside the Biden administration, will be so heavy that I cannot imagine any barrier to asylum. And in the end, it is a little bit strange because you're in the same proceeding anyway. So then it just becomes an issue of what is the relief available to you in this same proceeding where you would otherwise be able to get withholding of removal. So it's not like you're saving resources. It's just a matter of whether you're going to provide an easier legal path to success and whether you will be able to apply a better benefit if you win. And so those are the issues that are at play. And so that's where I think those protocols, the spirit of those protocols, if not the letter of them, will be re-brought into the statute, in that I don't think any barrier to asylum that was imposed in this administration will be retained in a subsequent administration.
Mm-hmm. And just so I'm clear, Leon, and that was a good explanation, but do you think kind of the drawing back of those barriers to applying for asylum is more in conformity with the protocol and international law?
Well, no, I'm not saying that what the Trump administration did in terms of limiting asylum violates the refugee protocol, because I think the refugee protocol actually gives countries leeway with regard to what additional benefits a country gives above and beyond what we as American immigration lawyers know as withholding of removal. Mm-hmm. I think withholding of removal is what the Refugee Convention requires. It's not the non-refoulement, as they say. But after that, the question is just how we as America interpret the spirit of these conventions. And we have always interpreted it as we don't particularly like the concept of people here in flux. And if there's a way to unflux them, we would do this. And so this is sort of the first administration that I think, as part of a larger strategy, I don't think it's just the flux issue, but has sort of made it so that if you succeed with your refugee claim, you're still remaining in flux forever because you didn't do one of three things properly. You didn't come through the port of entry, or you didn't apply for asylum in Mexico or Guatemala or somewhere else, or you you committed certain acts that made you now, in a discretionary viewpoint, not eligible for asylum anymore. They've added to those discretionary factors. And so those are the things that I see being unwound in a Biden administration.
Understood. Thank you, Leon. Enrique, it's the same question for you, really, which is, can you comment on how the Trump administration justifies the protocols under its international law obligations? And if you'd like to comment on anything that Leon brought up, please go ahead as well.
The difficult thing about participating on this panel is that I respect Leon so much, and he and I agree on a lot of things. But to also just show the contrarian perspective, not because I'm just offer the thought process. The first thing is one of change management, and that's what we've been going through. And change is difficult when properly managed. It's even more difficult when not necessarily properly managed. And it was time for a change. And what we are seeing is that the changes that have been implemented may not have been implemented as smoothly, as nicely as most people would want. But I think part of the shock comes that everybody's been expecting that this has been the status quo for 20, 25, 30 years. And so they were expecting it was going to continue forever. But that system was not sustainable, and that system being the asylum system. But let's look back further into the history of the history to a certain extent in international law of asylum and refugee status in particular. So in 1951, there was the Convention on Refugee Status, which was adopted. The United States, which had promoted it heavily, was not one. In fact, it was one of three countries that did not adopt the convention itself. And the convention was a very narrow convention as a result of World War II. For refugees who had been displaced, persons who had been displaced prior to January 1st, 1951. And it was geographically and in a time sequence, a very limited convention. So fast forward to 1967 or 1966 when they start negotiating the protocol. So the three countries, if I recall correctly, who did not sign on to the convention were the United States, Venezuela, interestingly, and Cape Verde. Fast forward onto the protocol, which was an expansion where they lifted the restrictions that the convention had on geography as to who would qualify as a refugee under those international standards, and also the time period in which you would be qualified as a refugee. 1967, the US does. But it's important to recognize that the US did not sign on to that original convention. It did sign on to the protocol afterwards. Now, with that said, there's an understanding from an international law perspective that an individual who signed, or entity, a country who signed on to the 1967 protocol is also bound by the convention, even though it was not voted. My understanding is that the protocol was approved by the Senate 98 to nothing, if I recall correctly, whereas the convention was not approved by the US Senate. So these are conscientious decisions that were made by the persons in power at that time. Well, fast forward 1967, the reality is that, as I was saying earlier, it's one of change management. So first, we would take the position that if you look at the protocols, that what the US government is doing is exactly at a minimum what is required under international law under the protocol, number one. Number two, I would take it one step further, that the US is an influencer in trying to promote change where there's a need for change. We are not the only country who are suffering through this problem. There are a number of countries that are suffering through this issue where individuals want to reach a final destination. So individuals will go through Greece, maybe leave Syria, go through Greece and end up in Germany. Germany is suffering from the same problem. But Greece is also suffering it from very much because a number of the other countries in the European Union are not cooperating and helping them in doing their fair share. Now, I know that the European Union, maybe within the last week or two, has announced or is about to announce some new protocols of their own for how to deal with it. But basically what it requires is everyone to chip in. And so the same thing has to be said about Central American countries, Latin American countries, all countries around the world have to begin to do their fair share. This is not going to be a unique circumstance that the United States is facing. We will only continue to issue if we continue to see other crises, whether they be a weather or environmentally related change. Let's say droughts that may strike countries. We're going to see people pushing for survival to reach to other destinations. So there has to be a balance on an international level. But what the current administration is doing would fall under what is deemed to be acceptable under international law and is no different than what a number of other countries throughout the world are doing. So that would be the perspective from the Trump administration. What we're doing is allowed. It is no different in many cases from what is being done by other countries. And there's a time for a change, and that time has already arrived. The United States is broken. It should not take an individual. And this is not something new. We saw this in the 1980s with the Nicaraguan refugee crisis when they were evading or trying to escape, escape from Nicaragua and the regime there, the Sandinista regime, where they would get here and it would take 5, 6, 7 years for their asylum claim to be heard. So we can make the errors that we've made in the past. And what this administration has tried to do is to say, okay, enough. Let's change it. Let's approach it from a different perspective.
Okay, thank you, Enrique. And I think, obviously what people in the sort of immigrant advocacy community would say would be something like, we have to comply also with the spirit of the protocol and the convention and think about as a country, yes, it may be that Greece does this, it may be that other countries treat refugees in this way, but what sets the United States apart from other countries? And, that's an issue of national identity, right? And then on top of that, and I think that's why this issue has created such division in the United States. And then also just to point out that UNHCR has released guidance, specifically in March of this year, calling for the border measures related to COVID-19 to be sort of more necessary, proportionate, and reasonable to the goal of protecting public health and sort of not overriding the protections and the spirit of the convention. So that the UNHCR itself did release that guidance, which brings me to our last question, for which we have actually no time left, but let's let's go to it quickly.
Just say yes.
Yeah, exactly. So we've been touching upon this, which is COVID and how this has affected the crisis at the border. The CDC issued an order in March suspending the entry of persons from countries where communicable diseases exist. And as a result, CBP is now expelling unauthorized immigrants, including many children, without considering whether they are eligible for protections under US law. So many argue that this is putting asylum seekers' lives at risk under the guise of public health concerns. Enrique, if the Trump administration is reelected, do you envision further restrictions on application procedures at the southern border, even if the COVID pandemic is ultimately contained? And can you comment specifically on policies affecting children, noting that current law requires special screening of unaccompanied children and their transfer to appropriate care? And if you can do it rather quickly, that would be great.
Essentially, I don't anticipate that there's going to be any significant move backwards from what the Trump administration has done. I would anticipate it only continuing to be geared up and advanced further from what we're seeing now. In terms of, Sandra, the more difficult question is one involving children. That one, being a Republican and still trying to provide perspective to the Trump administration, that's one that I think that the Trump administration has great difficulty justifying, and I'm not going to sit here and try to justify it either.
Okay, thank you. Leon, I would like your commentary on how a Biden administration would handle the issue of unaccompanied minors, and also comment on something that I think you brought up actually, which was that the whole concept of family detention was vastly expanded actually under the Obama administration. So do you envision a continuation of that?
Well, I think the family detention issue will only be revived if there was some massive surge, because I think this has become such an unpopular position in the Democratic Party that I think if your choices are MPP, family detention, or release upon CBP clearance, I think family detention would be third on that list. I think the Democratic base would want release upon CBP clearance, but the question is how manageable that is in a COVID crisis. I mean, the big problem is going to be, everybody knows that CBP has not, in 2015, 2016, 2020, doesn't matter what the year is, they can't handle a surge in their facilities. And a surge in their facilities with COVID is not a good situation. I don't know anyone who would want to honestly say this is something we should be wanting to happen. And so the question is, there will have to be some period, I think, where these provisions continue. And the larger question is, how do you draw that down? When do you draw that down? And how do you do it so that you don't immediately create a surge? Because if you immediately create a surge, then all of those bad options start to get placed back on the table, and you're going to have a ton of criticism on the fact that this wasn't a problem, it had been stopped, and now it's all back again. And so this is why it's very important, I think, and I don't know in the end who will win these political arguments within a Biden administration, but I personally, just my opinion, think you really want to phase these things down so that you don't create an imminent surge all at one time.
Okay, well, we could discuss asylum and refugee policy all day, but we don't have time for that. We'll move on to, but that was very informative. Thank you to both of you. We'll move on to the next question, which is a discussion on the president's recent proclamations and specifically restrictions on employment-based visas. So this administration has broadly used and implemented its authority to exclude certain classes of immigrants from the United States. In April of this year, the president issued Proclamation 10014, which suspends the entry of certain foreigners from the United States, excluding certain exemptions for lawful permanent residents, those in the healthcare profession, fighting COVID, spouses and children of U.S. citizens, as well as members of the armed forces. Then he followed up that proclamation with a second one in June, which suspended the entry of certain non-immigrant temporary workers, such as H-1Bs, L-1As, which are for executives and managers, J-1s, which for those listeners out there include interns, trainees, teachers, camp counselors, au pairs, and summer work travel exchange visitors, among other categories of visas that were excluded. As authority for the proclamations, the administration has cited to Immigration and Nationality Act Section 212F, which states that the president, that whenever the president finds that the entry of certain foreigners or classes of foreigners to the United States would be detrimental to the interests of the United States, he may, by proclamation, suspend that entry. So, Leon, if Biden were elected, do you think we should expect a continuation of these proclamations and others like them? Do you think that the Trump administration is lawfully using its authority under 212F? And if so, please explain to us why you think they are lawfully using it.
I think the first thing is on the INA 212F proclamations, that's the easiest thing for the Biden administration to just wipe out literally on day one. They can just wipe them out because those are not regulations. And so just as easily as you can promulgate them, you can wipe them out. And also wiping them out is also a bit meaningless because it doesn't really then create a flood of H-1B or L-1 or anything else, because you still got to go through an embassy and you still have to go through, get an appointment, do all of these things. And so you don't immediately feel anything. It's still, even by wiping out the proclamations, you still create a phased re-entry of these populations that have previously been banned, A. And then B, it's not like, let's talk about the travel ban one, for instance. It's not like we're going to start handing out thousands of visas to people from Yemen or Somalia or Sudan when these proclamations are over. But just what you're doing is you're creating an environment where there isn't a categorical ban that's put in place. That's sort of the idea of eliminating these proclamations. So I do think in relatively short order, if not the first week, I can imagine, you'd see the bans eliminated. Now, in terms of if Trump were to win, are these bans legal? I think, one of the interesting things about the Hawaii versus Trump decision is that they put all these caveats to it, because ordinarily, when you have a position like the original immigration positions from the 1800s, you should have a 3-line opinion. It's these people are not inside the country. It's a statute that Congress created and that the president passed. Finished. End of the case. But yet, that's not what we see in Trump versus Hawaii. We see thousands of pages of writing talking about we're not going to put a rational basis test on, but we're going to pretend we're putting a rational basis test on. And we're going to say that this did have a rational basis to do this. We're going to pretend that you have due process rights. We're not going to say you do, but we're going to say, okay, that if you have a facially legitimate and bona fide reason for the denial, you can do it. And so they put all these caveats in it because I do think they're worried, or here's the key, unfortunately, that court was worried that this could be overdone. The question is, what will a future court, because we don't know what a future court's about to look like, think about this? 2 judges have now changed since that decision. Kennedy and Ginsburg are both not on the court anymore since this Hawaii versus Trump decision. And so they've been replaced by individuals who, or will be replaced, or have been, 1 and 1, by people who are much more, sort of restrictionist on this. Maybe it is possible that they will return the immigration law if there's a Trump re-election to the 3-line decisions from the 1890s, which are Congress passed it, the president signed it, that's the end. That's all I want to know about. And if that happens, then you can do 212F for anything. And that's why I tell people, if you're going to pass any law, even if you can't pass comprehensive immigration reform, pass a law that bans 212F from being used for more than 90 days. You know, just at least, I totally get it. COVID, something else, 90 days, you need something. I believe in that. But then after that, Congress should have to reauthorize any ban that happens, because you could end up with very difficult uses of these authorities.
Okay, thank you, Leon. Enrique, can you take some time briefly, a minute or two, to respond to Leon's, very useful information, to Leon's comments from the point of view of the Trump administration. And, you know, again, a lot of the justification on these proclamations are for the US to be excluding people from countries that have, because of the COVID concern. But in reality, a lot of these countries have lower COVID rates than the United States. So that's also something I'd like you to address.
I start with the premise that 212F is a section of the Immigration and Nationality Act, as Leon points out, that was approved by a Congress a number of years back, that was signed by a president, and has existed that entire period of time. But let's also fast forward. Since 1981 to the present, every president of the United States has made use of 212F for whatever purpose they felt that was necessary, but they did. If you look back to the Obama administration, they used 212F on 19 different occasions. And prior to that, in the Clinton administration, they made use of 212F on 12 different occasions. What is 212F for the audience out there? 212F says that the president has the ultimate discretion to bar the entry of either all aliens, that's all persons who are not US citizens or permanent residents of the United States, all aliens, or any class of aliens. And that's what it's been used for, is for classes. Now, that's the first thing to look at. This is not something that's unique to the Trump administration. It's something that's been used on multiple occasions. But the second, just to wrap it up quickly for you, the second point is one that relates to employment. No one can reasonably say that we should have had interns and trainees and au pairs in the United States when we were all on lockdown, okay? So it was not an unreasonable usage. Now, that it may have gone a little too far, a little too long, that's another issue for another day, for another debate. But at the end of the day, it was intended primarily to protect American jobs. As we have between 20 and 30 million Americans unemployed, well, why should they be competing against the rest? And that's the logic. Being a business employment lawyer, that's not necessarily what I agree with, but that is the logic that's been put forth by the administration.
Okay, well, that provides a perfect transition to the next question, which is about skilled labor. So as you both are very aware of, there is fast track regulation in the works right now that would narrow the definition of specialty occupations eligible for a skilled worker visa under the H-1B temporary work visa program. And then a second fast track regulation that would raise the wages that employers must pay to demonstrate that foreign workers will not displace Americans in the same occupation and geographic area. These measures, along with clamping down on visas for international students and journalists, are basically what we're seeing as some of the president's final moves before the election. And these restrictions are being justified along with the proclamations as necessary to preserve jobs for Americans. So Leon, the unemployment rate has declined apparently to 7.9% in September. The Bureau of, it's still high, but the Bureau of Labor Statistics notes that these improvements in the market reflect a resumption of economic activity that had been curtailed during the pandemic. Do you think fluctuations in the unemployment rate will affect the Democratic Party's stance on skilled immigration? For example, if unemployment rates were to rise again, would we expect more restrictions on work visas for foreigners under a Biden administration?
As Enrique will vouch for me, I'm pretty sure, people are always shocked to hear that during our immigration reform debates, People thought, oh, you must have been fighting about legalization or the border wall or what. 90% of what we fought about was high-skilled immigration. And it made no sense because it was not on ideological lines. It was all over the place. And it was one of the most complicated and bizarre things that we spent 90% of our time fighting about high-skilled immigration. And so I honestly, as I sit here, I have no sense of if Trump is able to get through these regulations announced yesterday. Now, the one part I'll just say I only really have a problem with one part of this, which is this issue about tech workers is super complicated because it is true that you don't need a degree to do any tech job. You can just be a genius, so you don't need that. But you still need a visa to bring in tech geniuses into the country. And so this is a huge problem because if you say, oh, well, you need a degree, but look, Mark Zuckerberg didn't have a degree and he started Facebook. So no tech workers ever get to come in the country because Mark Zuckerberg doesn't have a degree. That's a bit of a mess. And I don't know how we fix that part of it. But the wage part of it and the third party placement part of it have actually been pretty huge Democratic priorities. And so I don't know that a Democratic administration unwinds those regulations. That is a very interesting question.
Okay, good. I'm glad I'm asking interesting questions.
Yes.
Enrique, what about, again, the view from the Republican Party in terms of the need to continue tightening and limiting the availability of employment-based visas? And I also want to really point out for both of you that a large number of important business associations, including, as you know, the National Association of Manufacturers, which is one of the, I think they employ more than 11 million workers, have filed a lawsuit opposing the second proclamation. And they argue that excluding workers will push investment abroad, inhibit economic growth, and reduce job creation. So how would the Republican Party respond to this?
So it's important for the audience, the international audience that may be listening in on this session, that the regulatory process in the United States is an agency will promulgate a regulation under something called the Administrative Procedures Act. That regulation will generally be published for public comment. And then after the public comment is received and absorbed, that a final regulation will come out. Now, that's not what's happening with the regulations that have been presented. In fact, this morning, they were published in the Federal Register to deal with narrowing the definition of specialty occupation and changing how they calculate what is called the prevailing wage at any wage level for individuals that are going to be brought into the United States. They're doing straight to interim final regulation. It means that they're going to publish it, but you're still going to have an opportunity to comment, but the regulations already go into effect. This is why I think what's going to end up happening with these two particular regulations is that they're going to go straight into litigation, and that you're probably going to see some type of national injunction staying these regulations from taking impact, because they will create a dramatic impact immediately. So the other thing is, as Leon pointed out, is this is where the far left and the far right, where do they meet, Leon? Where did we learn that the far left and the far right meet? They meet right together because they see this issue the exact same way. And so this is the interesting thing, is if you look at it from a business perspective, this will have a negative impact on the long-term viability of the American economy to remain competitive, especially in a tech-savvy world. That's the way that I would look at it. The difficult part is, from a regulatory perspective, Democrats and Republicans will line up, on the extremes at least, in the same column supporting this. And this is why I don't think you're going to see necessarily a change or a complete change. We know of one senator from a certain state in the Midwest, or two senators from two certain states in the Midwest, who would be completely, one is Democrat, the other one's Republican, who are completely in support of these regulations. So at the end of the day, the important thing here is the legal versus the practical. These are the legal measures that are being taken, but what are the practical impacts and implications of what's being done? Time will tell. Will this really have protected American workers? Will this really have saved their jobs? Or to the contrary, will it be a cause of higher unemployment in the years to come?
Okay. All right. Moving on to our third topic, everyone's favorite, the issue of the Dreamers and TPS beneficiaries. So Following the Trump administration's rescission of DACA and the termination of temporary protected status for many designated countries, there has been increasing pressure from both Democrats and Republicans to pass permanent legislation to protect Dreamers and certain TPS recipients. And again, I know none of us trust the polls, but the polls have been pretty consistent that most Americans want Dreamers to be able to stay in the country. And then many polls also say that longtime TPS recipients are integral members of our economy, and that without them, industries such as construction, restaurants, and landscaping would experience severe disruptions that could have ripple effects on the economies of several states. So Enrique, you first this time. Under a continuation of the Trump presidency, can we expect the administration to continue to take a hard line against both Dreamers and TPS beneficiaries? And then how is the administration justifying these policies given pretty much widespread support for more permanent immigration solutions for these groups of people?
So I would not expect the administration, Sandra, to change their line of action. I anticipate that they will continue, if reelected, to continue to go down the same path. And in fact, as we recently saw for the TPS cases, federal courts are finding that there's more likely than not that the government will prevail on their case, and that the government and the president had the authority to be able to terminate these programs. The TPS program is a program, again, if you want to talk about abuse, not fraud, but abuse, is TPS should be, the key word in TPS is temporary protected status. Well, if you look at Honduras, for example, we're going on at least 20, if not close to 25 years, where there's been TPS for Honduras, all because of Hurricane Mitch that struck back in the 1980s. Now, that they have not recovered from that, that's another issue, but it's not because of the hurricane that they haven't recovered. It's for a corrupt politics that occurs in that country. And so what ends up happening is you're going to see the government continue to move in that direction. The administration has the authority to be able to move in that direction. This is where it becomes difficult to argue, and I'll wrap up on this, is on DACA, it becomes an emotional argument. It tugs at the heartstrings that you have individuals who came here when they were children, brought illegally by their parents, had no say in whether they were brought or not. Well, at the end of the day, the responsibility lies with Congress. Congress needs to pass legislation. Congress has had that opportunity when the Democrats controlled both chambers under the Obama administration at the beginning, and they did not get it done. So this is an issue where it's our congressional leaders who are responsible for fixing this problem.
And Leon, just a little bit of a twist on that question for you. There's over 400,000 TPS beneficiaries from other countries in the US, with El Salvador, Honduras, and Haiti making up the largest groups. Considering high rates of unemployment, the COVID pandemic, what the heck else hasn't gone wrong in 2020? But do you envision a Biden administration renewing TPS for such a large group of beneficiaries?
Yeah, I can see a couple of things happening. We were sort of in the cusp of this at the end of the Obama administration, and I think this issue here is an example of sort of Trump providing an example for future administrations to emulate on moving with speed and not deliberating so much and not getting anything done. We were going to make TPS an admission for the purposes of green card entry. And now, the courts are split on this. And so I think if it gets litigated to the Supreme Court, probably the Supreme Court will say it's not an admission. I'd imagine. I don't know. That's my guess. But while it's still split, I think you could see a Biden administration saying it is an admission, so that provides as many people as possible a way to get a green card that otherwise wouldn't have been able to get a green card under the TPS strategy. Or they could end up giving advanced paroles to people. And I see the same concept on DACA. What the big challenge is going to be on DACA, if for some reason there's not a Congress that wants to pass immigration reform or can for a number of reasons, is the Texas case that's still lurking there on the DACA issue, that where it's not the DACA folks suing, it's the state of Texas suing to eliminate all these deferred action programs. And I think if that case goes to the Supreme Court, I am very bearish, given what that composition might be if you didn't have a change to the court in some other way, that you'd be able to keep these programs going. And so that would increase the need to move toward a legislative solution, because it is possible that no matter what the Biden administration wants to do, it won't be able to keep those programs in place because of the Texas litigation.
Okay, understood. And for those non-immigration attorneys out there, the issue of admission is a critical one, because once someone has been admitted, which is a term of art under the immigration laws, then their options for being able to adjust their status, get a green card, get on a path towards residency open up. And as of now, it's only in 2 jurisdictions. I think it's the 6th and the 9th Circuit that TPS holders are considered admitted. So it's an important issue. All right. Our last topic before sort of closing statements from both of you. And the last topic is about immigration courts and enforcement. So, as is well recognized again by both parties, is that the immigration court system has been plagued by systemic problems. And the courts, as we know, are housed within the Department of Justice. And that leads some immigration advocates to charge that the courts are especially vulnerable to executive branch interference. For example, the Attorney General can actually certify certain cases to himself to create new law, as they've done numerous times under the Trump administration. The Trump administration has appointed a former ICE prosecutor as chief immigration judge, and has appointed numerous other former ICE prosecutors as judges, which has also been done under previous administrations. But perhaps the largest problem is this tremendous backlog of more than 1 million cases. I think we're actually at over 1.1. So under this system, organizations like the American Immigration Lawyers Association charge that the administration is weaponizing immigration courts for the sole purpose of accelerating deportations rather than dispensing justice, neutral justice, which is what courts are supposed to do. So Enrique, how do you think the Trump administration has fared so far handling the issue of these backlogs in immigration courts? And what do you think we might expect in terms of reform, continuing reform of these courts under a second Trump administration?
So under the Trump administration, giving it a grade on a scale of A to F, I don't think anyone would be more generous than giving them maybe a C- on that scale in terms of their success. They have been rapidly appointing new judges. Now, what's important for the international viewers is the concept of the immigration court is an administrative law court. It is not what we call an Article 3 court under the U.S. Constitution. Article 3 courts under the U.S. Constitution, which are judges that are appointed for life, are the U.S. Supreme Court, the Appeals Court, and the 90-something district courts that we have at the federal level. The immigration court judges are political appointees at the end of the day. And thus, the quality of the decision-making is not always necessarily on par with what you would find in a Article 3 court. There are some excellent judges out there that do a great job. But the organization is becoming politicized at the end of the day. I would say that is the single largest existential threat to the U.S. immigration system is the lack of functionality of the U.S. immigration court system. They cannot get the cases in and out as quickly as they need to. And this is why the cases linger 4 or 5 years. Inadequate facilities, inadequate training, inadequate computer systems, inadequate number of judges. And the Trump administration has tried to address that by appointing additional judges. But it's a problem that's been created over the course of the last 3 decades. And it's not going to be solved overnight by one administration.
Mm-hmm. And so, Leon, Enrique actually brought up the issue that I was going to follow up on with you, which is there have been calls by different groups to actually pass legislation to create independent Article 1 immigration courts. I guess sort of like maybe bankruptcy or tax courts or Article 1 courts to address, these sorts of issues around too many politically motivated appointments. And do you think that is a cause that the Biden administration would be willing to get behind? And do you think that they have better solutions than
Well,
what?
I mean, I think the biggest problem that the Article 1 courts have as a concept is just there isn't a lot of intellectual bandwidth in the Congress for this concept. And then the idea of transmitting all these 1 million cases to a new court is you're like juggling, 100 balls in the air and you're trying to get from one car to another while you're doing this. Seems like an extraordinarily Herculean task. I think for me, it's a counterintuitive thing, but I think if you provided counsel to every immigrant and then made all the cases on an expedited timeline because you have counsel now, so you can't ask for continuances to find counsel, I think you could do a great job. I mean, you could give one for preparation, obviously, but what I'm saying is I think you could actually do a tremendous job shrinking the backlog on a concept like that. And it would be, that's the kind of I know a lot of people would say, oh my God, the government is going to pay for lawyers for foreign national people. It's a terrible thing to say. But if you really thought about it for 2 minutes and said, I can get rid of all of that continuance time that exists in these cases, because people ask for lawyers over and over and over again, and they ask for more time, and the judges don't want to be, evil people and not provide time for people to find lawyers. I think you could actually really find a way to expedite the system, and you could create rules that allowed you to do that. And so I think there can be more done with providing things with regard to certain countries and with regard to, you could build in evidentiary presumption as to certain countries, so you don't have to argue in every single case. Let me find an expert that says in this country, this is a problem, et cetera, et cetera. There's things that can be done, but just nobody's really putting that thought process into it. Now, I just want to address very quickly one thing, because I was in charge in the DOJ, along with Juan Osuna, who now passed away, unfortunately, of doing the immigration hiring for immigration judges. And even in the Obama administration, we had 90% of our applicants were ICE attorneys because they were the only people who wanted to be immigration judges. We wanted to find from many places, and whenever we found anybody who was qualified, who was not an ICE attorney, we would put them in. But it's important to know that 90% of the applicants for immigration judge positions are ICE attorneys, and so it's very hard to not find ICE attorneys to put in those positions.
Mm-hmm. Well, thank you. You bring up lots of interesting points there, and it's always good that at least we have ideas, right, that we can consider. So just in conclusion, I think we touched upon just some of the major issues that this country is dealing with in terms of its immigration system. And there's so many issues. I mean, the asylum and refugee policy questions, maintaining American competitiveness, addressing labor shortages versus overall high unemployment, a deportation system that is clearly outdated and backlogged and that has problems attracting judges that are not ICE attorneys, as you mentioned, Leon. And then we haven't even gotten to the cessation of visa processing at all the consulates around the world. Some of those are opening up on a limited basis at this point. So all of these issues are going to require an administration that can strike a balance between finding and implementing practical solutions and also theoretical questions and ethical questions about defining what kind of country we want to be from a U.S. immigration point of view and how much the international law perspective really matters to us. So in other words, and it sounds sort of cliche, but it's true. Are we going to continue to be the country who welcomes immigrants from all nations and from all different backgrounds? Or has that conception of America somehow no longer become as relevant? So I'd like both of you maybe take 2 minutes each, and then we'll stop to address Enrique with you first. Can you explain to us why, given all of these problems and challenges, why the Republican Party might be best equipped to tackle these issues and offer the best solutions moving forward?
So thank you, Sandra, and thank you, Leon, and thank you to Asylum for the opportunity to present today. The reality is that America has been and hopefully will continue to be, as always, the land of opportunity and freedom for everyone who chooses to come to the United States. But the emphasis now is going to become one of those being placed on those individuals who choose to do it the right way, who choose to abide by the law, who choose to come. The reason people come to the United States is because they feel secure, because they feel that there's opportunity here. We need to make sure that we take all the necessary measures to preserve those opportunities and that security. Is something that we didn't focus on too much is the issue of national security today, but that we secure that opportunity and that freedom for everyone. With that said, we need to ensure that the people that come here have a respect for the law, and that those individuals will also inculcate themselves into our system, into our culture, into the monolithic culture that is the United States. So unfortunately, sometimes it calls for change that people don't want to accept because people want to maintain the status quo. It's one of the problems with Congress is that everything continues to be the status quo, and you don't see ingenuity, you don't see innovation, you don't see leadership in a lot of cases. And so that's where the Republican Party is the party that is not afraid to take the lead on those issues, which are going to keep America at the forefront.
Thank you. Leon?
I think we're at a crossroads here between the politics of pre-COVID and the politics of post-COVID. And maybe post-COVID, we will all return back to the politics of pre-COVID, where Democrats want certain things out of immigration and Republicans want others. But I personally, and maybe this isn't the answer you wanted, struggle with a world where if you can do every job from your house, why do you need immigration? Why do you need it? Why do you need anybody going anywhere? And these are very complicated questions we're going to be asking over the next few years. And the question is, maybe we won't ask them. And maybe we will just, and then for at least for all of us immigration lawyers, if we ask them, I hope that we ask them later, not sooner, because all of us will be in big trouble if we ask these questions too soon. But at the end of the day, I don't see a return back to 2016. That world is gone. This is a new world. And the question is, how will those policies in a Joe Biden administration be implemented to fix this new world? And I don't think anybody has the answer to that question because too many things are changing all over the landscape. And I think what will be universal is that at least they will be viewed from a prism of saying, we want to be as compassionate, as open as possible under the circumstances. And I think from that perspective, that I hope will be the core of the Biden administration is, the tie will go to the runner. And in this case, that would be the idea of allowing the compassionate answer to prevail. But I just think that the questions have changed and we don't even know what the questions will be even 3 months from now. And so that's what's going to be the complication.
Okay. All right. Well, I want to thank both of you for your time and for your insights and perspective. I do think it's an American tradition that we all want to keep, which is the ability to have dialogue and share ideas. And hopefully we will be able to go back to that, no matter what the outcome is of this election. And I also want to thank Asylum for bringing up this topic. It's a very important one. And thank you all for your participation.
Thank you.
Okay, and we're clear. Thanks, everyone.
All right.
Thanks, everybody. Thank you.